So in this video, I want to give you a little bit more information about what PCT applications are and how they work, because there are a few very esoteric aspects to filing a PCT application, and I want to make sure that you know about all of those. So one way you can get into the situation of having a PCT application is that you file a patent application in the United States. If you're a resident of the United States, you would file in the United States. Now, one point I'll make about this is if you're not living in the United States, this is also information that you can use, because the Patent Cooperation Treaty, if you're living in a country that's a signatory to the PCT, most countries are going to have a law that requires you as an inventor resident in your country to file your patent application in the patent office of the country in which you reside. So, for example, if you're living in China and you're an inventor and you've developed an invention, you will file your patent application in the Chinese patent office initially, and then subsequent to that, you could file a PCT application. So the main point is, this is why I'm calling the first patent application a primary patent application, because it's the first patent application, and where it gets filed in is going to depend on your country of residence. If you're a United States citizen, you're going to file it in the United States. If you're a citizen of another country and you've invented in that country, you're going to file in the patent office of your country, most likely initially. Now, once you file, the priority date of that application is the filing date of that application, assuming there were no earlier file applications. And I explain the implications of having a provisional application in a video on protecting your invention in other countries, which is linked here. For purposes of this explanation, I'm going to operate under the assumption that the primary patent application is filed on date X, and date X is the earliest priority date for that application. In that case, you then have 1 year, so X plus 1 year to file a PCT, what's called an international patent application. So the PCT International Application gets filed in what's called a PCT receiving office. Now, if you're in the United States, the United States Patent and Trademark Office acts as the United States receiving office for PCT applications. And so you can file your PCT application in the USPTO as the United States PCT receiving office. At that point, you're assigned a filing date, an international filing date, and the PCT, Patent Cooperation Treaty, gives you 30 months from the priority date, which is the filing date of the primary application. You have 30 months to file what are called national stage applications. And the national stage applications are filed in countries that are signatories to the PCT, and it depends on what countries you decide you want to file in. So if you decide you want to have patent protection in Mexico, you then file a national stage patent application in Mexico from the PCT International Application. If you want patent protection in China, you file a national stage patent application in the China Patent Office. If you want patent protection in Canada, you file a national stage patent application in the Canada Patent Office, and so on. Now, once those national stage patent applications are filed, then that country's patent office takes over, and they're going to do an evaluation of your claims, and you're going to go through the patent prosecution process in that country's patent office, the same as you had to go through the patent prosecution process in the United States in order to prosecute your primary patent application. So you need to have a local counsel in the country, or at least you have to have a local counsel who's authorized to practice law in the country where that patent office is located, so that they can file documents and make arguments. If you have a U.S. patent attorney, your U.S. patent attorney is going to work very closely with those local counsel to coordinate the prosecution and make sure that the arguments and claims are consistent with the arguments you've made in the primary patent application. But that's something that we'll discuss in more detail in another video. The main thing to take away from this video is that a PCT International Patent Application can be filed 1 year from the primary patent application filing date, and then gives you 30 months from that original filing date to decide where you want to file national stage applications and to make those national stage patent application filings. Now, there is another way that you can use the PCT, and that is you can use the PCT directly instead of filing the primary patent application, for example, in the USPTO. If you're a United States citizen, instead of filing in the United States PTO your primary application, you can file your primary application as a PCT patent application initially. So you can file an international application as a PCT, but then you now have the 30 months from the filing date of the PCT application in which to file your national stage applications. So if you're doing this in the United States, you would have to file your United States patent application in the USPTO as a national stage application on or before the 30-month deadline for filing national stage applications under the PCT. So this is another way that you can use the PCT, and reasons you may want to do this can vary. For example, it may be a cost consideration. You may want to save the cost of filing the U.S. application initially, since you know you're going to file a PCT. You file the PCT initially. Now you have 30 months to gather resources and wait before you have to pay the USPTO filing fees for the national stage or any of the other countries' filing fees for the national stage. So you get that 30-month deferment of fees in that sense. However, it's more expensive to file a PCT application. A PCT patent application filing costs a good deal more than filing an initial patent application in the United States Patent and Trademark Office, USPTO. The PCT fees are higher than a United States direct patent application filing. So from the standpoint of cost, another thing to be aware of is that if you file a primary application in the USPTO, you're going to have that filing fee cost and that prosecution cost. Then when the 1 year deadline comes up and you file your PCT application, you're going to have another filing cost for filing the PCT patent application. And then 30 months out, you're going to have the cost of filing the national stage applications and then all the prosecution cost that goes with that. So all of those costs are a consideration. There are strategy decisions involved in how you use a PCT and when you file a PCT and why. But generally, the takeaway for you from this video is to know that if you file a patent application initially, you can do a PCT international application within 1 year from the filing date of your U.S. application, and then that gives you 30 months to decide what countries you want to file national stage patent applications in. The other option being you can file your PCT directly, and then 30 months decide what countries you want to file in, and the United States might be one of them. In that case, the United States would be a national stage filing. So that's a general synopsis of the Patent Cooperation Treaty PCT patent application process.